Good morning, everyone. Welcome to the Judiciary Committee this Wednesday morning, the 10th of February. My name is Carl Rhodes. I'm the chair of the committee. This Zoom meeting and YouTube live stream event will include the following two agendas: a decision-making agenda at 9:10 for 5 bills: SB 548, SB 550, SB 551, SB 556, and SB 612. And then there will be another hearing agenda at 9:15. The members of the committee who are, I think everybody's here, almost everybody's here. The members of the committee are myself as chair, Vice Chair Jarrett Keokalole, Senator Ocasio, Senator Gabbard, Senator Lee, Senator Kim, and Senator Favela. This meeting, including the audio and video of remote participants, is being streamed live on YouTube. You will find links to viewing options for all Senate meetings on the live and on-demand video page of the legislature's website. In the unlikely event that we have to abruptly end this meeting due to a major technical problem, the committee will reconvene to discuss any outstanding business on Friday, February 12 at 9 a.m. and a public notice will be posted and it will be video conferenced. For the people testifying remotely, all testifier audio will be muted and video disabled until it is your turn to testify. There is a 2-minute time limit per testifier. If there are temporary technical glitches during your turn to testify, we may have to move on to the next person due to time constraints. We appreciate your understanding and remind you that the committee has already received your written testimony and read it. But we will try to come back to you if it's a short problem. I'll be reading a list of people for the second agenda. I'll be reading a list of people who submitted written testimony for each measure. We apologize if the closed captioning doesn't accurately transcribe the names or if I butcher your name. If you're interested in reviewing the written testimony, please go to the legislature's website, www.capital.hawaii.gov. You'll find a link to testimony on the status page for the measure. And I believe that's all the announcements for the moment. So I think we can just go ahead and go straight into the DM for, oops, wrong set of papers. Go straight in for the 910 DM. I don't think there's any reason that we need to go into a separate room to discuss it unless somebody has an objection and we can go to another virtual room and talk about it. Okay, looks like we're okay. Let's go ahead and go on to DM on SB 548. This is relating to elections by mail. Makes amendments to election law to clarify the administrations of the new elections by mail law. Rename, it does a whole bunch of things, so I'll leave it at that for the summary. Recommendation is to go ahead and move it out with quite a number of amendments. We did send around to all the members our internal outline on what the bill does, just so you could take a look at the amendments if you want to. I don't think there's anything particularly controversial, but there's a lot of them. So I will read through them here once I find them. Okay, here we go. So we'll delete section 2 of the bill that would have removed Election Day as a state holiday. So we'll leave it as a holiday for the time being. I know there are other bills out there to swap Election Day for another one, but we'll deal with that with separate bills. We'll add amendments to HRS section 11-132 regarding the 200-foot radius where one cannot campaign, to specify that it includes any line of voters at a voter service center, place of deposit, or its appurtenance, as a word I know what it means, but I never use it. Add a new statute to require a minimum of 4 precincts in each district, and for each inhabited island of at least 100 residents required that there be at least 1 precinct for those islands. Add a new statute to establish special needs advisory committees at the state and county level. And this is taken from SB 533. So if you want to look at the details, they're there. In the affidavit that a person signs when registering to vote in HRS section 1115, we'll add the option for the registrant to acknowledge that they cannot read standard print due to a disability and are requesting an electronic ballot be sent to their email address. In HRS section 1124 regarding the closing of the register, correct the statutory references to HRS section 11-15.2 and clarify the means by which a voter registration application may be received as requested by the Office of Elections. In HRS section 11-106, revert to existing law that allows 5 business days to cure a deficient ballot and not the 7 calendar days that we had proposed in the bill. Also was requested by the Office of Elections. In HRS section 11-102, change the time frame for mailing of ballot packages from approximately 19 days before the election, which is the current standard, to at least 18 days before the election to allow for earlier mailing of ballot packages, and add a disclaimer so that the state and counties are not liable if the package is mailed less than 18 days before the election or it's received less than 18 days before the election. We'll add language requiring the Department of Public Safety to inform persons on probation or parole that they may vote and provide information on how to vote. In HRS section 11-108 will allow ballot processing for tabulation to begin earlier by changing it from the 10th day before the election to the 18th day before the election. So they can, as it was in this last election, they'll be able to count, but they can't release the information, but they can get started on the counting. Okay, then we'll add a session law, a requirement that as soon as practicable, the Office of Elections and the county clerks are to examine and apply the specific factors identified by Common Cause in their testimony regarding the determination of the optimal number and placement of voter service centers and places of deposit. And then there'll be technical non-substantive amendments, including changing overlooked references to election day to closing hour of voting, precinct official to voter service center, and consistent use of prior and before. And I believe that's it. Any questions or concerns? Seeing none. Okay.
Can you go over all of the amendments again, please?
If you'd like me to, I can.
Just kidding.
Okay. So Vice Chair, we have the vote sheets. And so I think, well, I guess you're there right now, aren't you?
I can take the vote.
I've already signed it. It's probably not supposed to tell anybody this, but I've already signed blank ones, so you don't need to bother. But if you don't mind taking the vote, that would be great.
Okay, members, voting on SB 548. The recommendation is to pass this measure with a lot of amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee is excused. Senator Favela.
Reservations.
Reservations for Senator Favela. Chair, your recommendation is adopted.
Thank you very much, members. Next up is SB 550. This allows an individual who is 17 years of age but will be 18 years of age on or before the next state or local general election to register and vote at the state or local primary election immediately preceding that state or local general election. Recommendation here is to go ahead and pass it. Do have some amendments though. Okay, there we go. So we'll allow 17-year-olds who will turn 18 years of age by the general election to vote in the preceding primary election for all races, not just state and local, and in any intervening or co-occurring special elections. So conceivably, you could have we think you could have a special election between the regular primary and the general. And since we're letting you vote in the primary, we'll let you vote in that intermediate one. And with regard to the federal elections, some states already do this. So it's a little cutting edge, but it looks like it can be done. So that's what I'm recommending. Because otherwise, I'm sorry. Let me finish my phrase, and then so the reason is because if we don't do that, then you'd have to have a special ballot. The underlying equities aside, if you don't let them vote in all elections, then you have to have a special ballot for people who are not 8 or that are 17. And then there's one other one. So we'll also accept the AG's recommendation to delete unnecessary requirement that the chief election officer or county clerk promulgate rules regarding the confidentiality of the 17-year-old's addresses and phone numbers and their texts as well. Okay, I'm sorry, Senator Kim, go ahead.
Was it applied to the neighborhood board elections from the county?
That's a real good question. Staff, do you know the answer to that? Jesse, I guess you're working on this one.
I do not. I believe that is under the county ordinance and we'd have to check those requirements.
I think that's correct. I think that's an entirely separate system because the state doesn't get involved at all. It's all ordinance and
Right, but we could override that. I mean,
could.
yeah. I was just curious if the bill could.
Do you want to? I mean, I don't.
No, I'm just.
Okay. Okay. We'll leave it this way for now anyway. Any other questions or concerns? Okay, if not, Senator Keokalole.
Okay, members, we are voting on
550, SB 550.
SB 550 with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Senator Lee is excused. Senator Favela.
Aye.
Chair, recommendation adopted.
Thank you very much. Next up is SB 551. This is the constitutional amendment pair from the previous bill. It's a constitutional amendment to allow individuals who are 17 to vote in the primary before the first general that they're eligible to vote in. Similar amendments to what we had on the previous bill. It'll allow 17-year-olds who turn 18 years of age by the time of the general election to vote in the preceding primary election for all races on the ballot, including federal and any intervening or co-occurring special elections. We'll accept the AG's recommendation to apply the constitutionally allowable residency required of 30 days. We're not going to amend the existing one-year residency requirement in the Constitution, which isn't enforceable. It's 30 days that we enforce, and there are texts as well. Questions, concerns? If not, Vice Chair.
Members, we're voting on SB 551. The recommendation is to pass this measure with amendments. Noting the excused absence of Senator Lee, members, are there any reservations? Any opposition? Seeing none, Chair, all other members vote aye. Recommendation adopted.
Thank you very much. Next up is SB 566. This would increase the homestead exemption for all persons up to $2 million and require that the real property be the principal residence. Recommendation here is to go ahead and pass it, but to significantly change the amount involved. I'd like to lower it to $350,000. It hasn't been raised in many, many years. And I think there is an argument just to adjust it for inflation, but also the people who lose lawsuits, the goal is not to make them homeless. On the other hand, I don't see why you should be able to keep a $2 million home if you've lost a lawsuit that's big enough where you'd be in jeopardy of losing it. So recommendation is to change the amount to $350,000. Questions, concerns? If not, Vice Chair.
Members voting on SB 566, the recommendation is to pass this with amendments. Noting the excused absence of Senator Lee, members, are there any reservations?
Reservation.
We have reservation for Senators Favela and Ocasio. Any other reservations? Any other opposition? Seeing none, Chair, all other members vote aye. Recommendation adopted.
Thank you very much. And that brings us to SB 612. This establishes the offense of criminal trespass on critical electrical infrastructure. This bill didn't start out very controversially, but as you're probably all aware, we've been getting dozens, if not hundreds, of emails in opposition. So I'm going to make a recommendation, and if you guys are okay with it, great. If not, that's fine too. So the recommendation is to pass with amendments. We'll expand the definition of critical electrical infrastructure to include transmission equipment and appurtenances to government facilities per the DOT testimony. But keep in mind, this has to be something that's fenced. So fenced and signage so that you know that you're going onto something you're not supposed to be in. And then we'll use the AG's burglary language. They gave a couple of different options. So I'll read that. The person intentionally enters or remains unlawfully on a critical electrical infrastructure which is fenced or enclosed in a manner designed to exclude intruders with posted warning signs, private property, critical infrastructure. Although for the DOT amendment, it won't say private property. It'll say something else about a restricted government property. And the person recklessly disregards a substantial and unjustifiable risk that the property is a critical electrical infrastructure with intent to commit therein a crime against a person or against property rights. And then I'm also suggesting we use the AG signage language as well, which reads private property, or in the case of the DOT amendment, restricted government property, critical infrastructure, gives the HRS site no trespassing. The sign or signs containing letters no less than 2 inches in height shall be placed at reasonable intervals, no less than three signs to a mile along the boundary line of the land and at roads and trails entering the land in a manner and position as to be clearly noticeable from outside the boundary line. Well, that's the recommendation. Comments, concerns?
Comment, I had concern.
Senator Favela.
Yeah, I have concerns because I know this was asked by Hawai'i Electric in other cases. But the concern I have is that they already have protection under the new Terrorism Act. They already have federal protection. And then here we are going to make another ruling or law, whatever you want to call it, because it wants to make. See, this is something that you guys setting everybody up to be criminals going forward with these trails and these side roads and everything, because they know for a fact they have plans to continue to try to push solar farms on ag land and pushing windmills that what the community don't want with transparency. So they want to protect themselves way ahead of time. If somebody enter a plant now, a friend of them used to be security for the plant right there in Pro City. If somebody enter there and they're not unlawfully belong there, they already got criminal trespass under the Federal Terrorism Act. So now we're going to put trails and roadways and all of these other things there to only highlight and to protect the ongoing improper, not even being transparent going forward in how they're doing their a new renewable energy. So I really saddened that we had to come to this and then letting them dictate on the House and the Senate side for pushing something like this for extra measures. So if they put on sign on the road going through the construction saying private property, government property, it wasn't there 6 months ago, but they're gonna put them because they know the project is coming. And now it's gonna prevent anybody, law-abiding citizens, to invert their right to disagree with the development. This is gonna be something that's gonna later on, gonna catch us all back later on and bite us on the okole. So I'm just saying this is really very concerning because you guys are giving them a free open road to start putting signs like how they did in Kalailoa for the windmills, right, with AES, and they had no proper signage. Signage was put out there illegally with no permits, and now we're gonna give them a bill to say now 6 months before the project, they're gonna put all these signs to make sure that nobody that wanna go over there and go against their project because it was not transparent from the beginning, to make them all criminals. So I'm voting no on this measure, and I'm kind of disappointed that we didn't defer it. Thank you.
Let me just respond briefly. So yes, it's true that these trespasses like this are already legal. On the federal side, I don't really know, but we don't have any control over that at the state level anyway. But there have been instances, of course, where very dangerous things have been done. I forget, somebody sawed off I think it was a supporting bolt for one of the big windmills. That could have, I mean, that's very dangerous. So yeah, I understand what you're saying. I think this is necessary because the current people who are getting caught currently doesn't seem to be having any effect. So yeah, anyway, I'm sorry, there was another question over here or comment. Senator Ocasio, go ahead.
I actually echo those concerns. And as I was looking through the testimony that was coming in since our last hearing, a huge majority are my constituents. And it particularly relates to the development of Honua Ola Hu Honua. So I have huge concerns. And I think it would be better to have deferred it at this time. And the question I have then, it may be rhetorical at this point because we don't have the specific answers, but how many of, Chair Rhodes, you mentioned that there are crimes occurring, and I would just question how many are actually occurring, and is it really big enough of an event or amount of that to warrant this kind of language in this measure. So I will also be voting no, and it's a very strong no. And thank you.
Thank you. Anyone else?
Yeah, I have a comment, Senator.
Yeah, Vice Chair, go ahead.
So I have reservations with this bill because I don't like the trend that the legislature has, I think, embarked on in the last several years of specifying particular activities for enhanced criminal penalty. I think we need to take a broader look at the criminal, in this case specifically. I think it probably warrants a discussion around whether there should be a broader general criminal trespass offense that can be elevated to a misdemeanor level. When we specify activity of this nature, as the legislature and as I have supported in the past, I just am concerned that the criminal code is becoming too complicated and too specific. And we're kind of gnawing around the actual problems here, which is that the code in general does not allow the prosecutors' offices in the different counties to capture the criminal activity in a way that actually facilitates justice. And so those are the reasons why I'm concerned about it. I think it is too specific.
Okay. Senator Kim or Senator Gabbard?
Yes, I have questions. I also have some concerns as well. And so if a project is designated, and as it was raised regarding the path to the project, and that path is in fact not part of the project or not part of the private land, would that be also fall under this measure, and people could be arrested? Or
well, it would have to be fenced or enclosed. So the path itself, it wouldn't fall under that definition. It has to be fenced or enclosed, unless the path is beyond the fence. But that would, there has to be a fence.
And is there any attachments to the fence would also be a?
No, I don't think so. That was the other bill that we were looking at the other day.
Okay.
As far as we've been able to determine, attaching stuff to another person's fence is not a trespass.
Okay. Well, those are the questions, but I do share some of the concerns that was.
I mean, if the consensus of the committee is that we don't want to move forward with this, I'm okay with that. I mean, it is what it is. So
in light of the serious concerns, I would, support.
Okay. I'll just defer it. That's fine. We can continue the discussion. And so this one, after having consulted with my colleagues, we'll defer this measure indefinitely.
Thank you.
Okay, that ends the decision-making part of the agenda. We will switch over now to the 9:15 agenda, which is a hearing. First up for the hearing is SB 385 relating to the Uniform Trust Code and Acts of the Uniform Trust Code. Find my testifier list. First up is Rhonda Griswold testifying for the Judiciary, State of Hawaii. Good morning.
Good morning. Thank you, Chair Rhodes and other members of the Senate Committee on the Judiciary for giving me this opportunity to testify. Before we talk about the Uniform Trust Code, I just want to compliment you folks on the work that you're doing. It's a privilege for me to sit in and watch this action on decision and watch you folks at work. So thank you for your service and the thought process and the thoughtfulness that you give to your job. My name's Rhonda Griswold. I'm an attorney member of the Uniform Probate Code and Probate Court Practices Committee, which is chaired by the Honorable Mark Browning. We've submitted written testimony in support of Senate Bill 385 on behalf of the judiciary. We've worked on this proposed Uniform Trust Code for the last 3 to 4 years, and we believe that it provides valuable guidance to estate planning practitioners, to trustees, and to the court in the administration of trusts. Our written testimony summarizes and provides highlights of the proposed UTC together with specific changes that our Hawaii committee has recommended. I won't repeat all of that testimony here. I'm just available to answer any questions that the committee might have about this proposed legislation. Thank you.
Thank you. Next up, we have Blake Oshiro, Commissioner on the Commission to Promote Uniform Legislation. I don't see him.
Hey, Senator. Blake Oshiro is not in the Zoom room at this time.
Okay. His testimony was in support as well. That's all the testimony we have. Members, any questions for Ms. Griswold? All right. Thank you very much. Thanks for coming in today.
Okay, thank you very much.
You're welcome to stay around and watch some more if you like, but you don't have to.
I'm afraid I have work to do, but
Yeah,
thank you again.
I figured it might be an issue.
Take care.
Thank you. We will go ahead and move on to SB 402. This provides that expenditures by candidate committees may be made to reimburse other individuals for expenditures advanced by those individuals in addition to those advanced by the candidate. So if someone goes and buys something for your campaign at Costco and you want to reimburse them, you can reimburse them as opposed to having only the candidate him or herself do it. Deletes candidate reimbursements from the category of expenditures that non-candidate committees must itemize in their report, since non-candidate committees are not allowed to receive or make loans. Okay, on SB 402, first up we have Gary Kam for Campaign Spending Commission.
Good morning, Chair, Vice Chair, members of the committee. The commission will stand on its written testimony in support.
Thank you. Next up is Sandy Ma, Common Cause Hawaii. Good morning.
Good morning, Chair, Vice Chair, members of the committee. We support this bill. We think it will improve transparency in the process. Thank you.
Thank you. That's all the testimony we have for SB 402. Members, any questions? Let me just double check and be sure I don't. Nope, I'm good. Thank you very much for being here. We'll move on to SB 404. This increases the monetary threshold that requires disclosure of electioneering communications, requires that disclosures of electioneering communications occur on the date the electioneering communication is publicly distributed, as opposed to when it's paid for as it is now. Classifies election advertisements sent by mail at any postal rate as electioneering communications, and it has some other more technical things. First up on SB 404 is Gary Kam, Executive Director, Campaign Spending Commission.
Good morning, Chair, Vice Chair, members of the committee. Briefly, we are attempting to lessen the burden of filing these statements of information on committees. We did put that threshold of $5,000, which is raised from $2,000, thinking about House races and looking at expenditures, and we figured that, and again, just looking at the reports and not asking any House member, that it's about $3,000 to do a district-wide mailing. We have started looking at all of the electioneering communications to try to get a better sense of where the numbers lie, but we haven't been able to do that as of today. we were more focused in reviewing the final election period reports and the recent supplemental reports, but we will have those figures shortly. The other thing about that's important is the changing of the disclosure date from when you make the contract to 24 hours after the ad is run. We believe that will take out a lot of confusion on trying to figure out when a contract for an expenditure is made. Thank you.
Thank you. Next on 404 is Sandy Ma, Common Cause Hawaii. Morning again.
Morning. Thank you, Chair, Vice Chair, members of the committee. We are concerned about raising the disclosure rate amount, from 2,000 to 5,000. We're concerned because that will lessen the transparency for some smaller races, especially county council races. We think increasing the rate to 3,000 would be more reasonable. We think that will allow some smaller county council races to also be able to file statements of information. That would be a more reasonable amount. We understand district-wide races, but smaller county council races should also have to file statements of information for electioneering disclosures, and that's a more reasonable amount that would cover all races fairly and equally, and not just focus on statewide races. And we also think that the definition for disclosure date should remain the same. Should be when has made expenditures for versus when when the communication is publicly distributed. And that's because a person could make the contract and then wait to have the electioneering communication be distributed, and then we could lose out on when the filing is made, the statement of information is made until election day. And so right now, if you make the contract, you have to file your electioneering communication, and that gives us a better understanding of electioneering communications versus bunching it all up on election day, and that does not favor transparency. So that's our main concern, those raising the rates too high and changing the date. Thank you.
Thank you very much. That's all the testimony we have on SB 404. Members, questions? Senator Kale Kaloli.
Yeah, for Common Cause, Sandy, I get your concern about the disclosure date definition, but have you considered on Oahu, for example, a number of printing houses have shut down in the last several years. And so what has happened in prior races, and I know this because I'm an incumbent, and I'm actually appreciative of the commission for considering this, because these rules, I think, they can get extremely cumbersome for new challengers. Incumbents know, and sometimes through experience from committing violations, incumbents know the rules and can adjust. New campaigns are in a much less advantageous position of having to adopt all these things. And I have seen in prior years where the mail houses themselves, just as an example of one type of electioneering communication, the mail houses will get so backed up nearing the date where the mail ballots are sent out that they take orders and then they invoice after the fact. So I understand you're accounting for perhaps the malicious attempts of campaigns to place orders and then potentially manipulate this definition by filing disclosures after the fact. But I'm wondering if you have accounted for the reality that often happens at the end of very busy election seasons, where printing houses will take orders and they will do invoices later because they are just absolutely swamped. In which case the disclosures under your, under the current definition, the disclosures come sometimes, potentially sometimes weeks, maybe months after the actual election is taking place.
Thank you, Vice Chair. So I understand your concern, and that's a valid concern. We would like it if the contract date is used. So when a contract is made with the printing house, the contract date, the date that the contract is entered into should be the date that within 24 hours, the statement of information should be filed. And we would hope that that is made clear to every candidate and candidate committee. That is when electioneering communication statement of information is filed with the Campaign Spending Commission. I don't know if Mr. Cam would like to clarify that any further.
Yeah, Vice Chair, you've got the floor if you want to ask more. Go ahead.
Gary, I understand Common Cause's concern. I just, having seen it happen because I am an incumbent and I have that advantage of experience. When things get very busy in the election season, sometimes it is difficult for the printing houses themselves to understand when they've had a meeting of the minds with a campaign in order to execute this. I've seen this disclosure, this electioneering communication requirement become very confused because of the speed in which information and things have come out. So I guess is that part of the impetus for why this bill is being considered?
Yes. So we've been trying to change the disclosure date for a while now. I recall back in 2016, I had a meeting with Representative Nishimoto, and we were talking about electioneering communications. And the first thing that he actually told me is, as we are sitting here today, and it was January before the session started. He told me that as we are sitting here today, I'm in violation because I submitted I had a contract earlier in January, and of course the 24 hours had passed. So I don't know if that was his situation, but it's if you have a contract in January to do an electioneering communication that runs 30 days before the primary, people in January, when you file the electioneering communication statement, aren't really looking at advertisements that are coming up. So they're not necessarily looking at these disclosures. I think it's only when the advertisement actually hit the public, that's when people start thinking, well, I wonder what's behind this electioneering communication. So I'm not sure if Representative Nishimoto was facing that problem that you raised, or he just does everything early like that, or he knows what he wants done, say 1 week before the primary election. But that kind of discussions prompted the commission trying to change the disclosure date.
Well, I'm sure Representative Nishimoto clarified the whole situation and took care of it all and is now in compliance. I am just concerned if we leave the statute as it is situated, that after the fact disclosures could potentially be manipulated, and then you don't get the reporting of electioneering communications until sometimes weeks after the actual election and the ballots have been counted and a winner has been decided. And I think that there's a real danger of that continuing and potentially being manipulated in the future if we leave it as is. So thank you. Thank you, Chair.
May I add one extra thing?
Okay, go ahead. Please be quick.
Sorry. Yes. We're actually relying on a U.S. Supreme Court decision, McConnell versus Federal Election Communication 540 U.S. 93 at page 200, and so which talks about relying on the contract date. So that's what we're basing our recommendation on. So
okay.
Thank you.
So I can understand that. And so I'm basing my recommendation off of seeing the activity happen as an incumbent and telling you right now that incumbents have an advantage in this scenario that could potentially be misused because the statute is situated as it is. So thank you.
Members, any other questions? Senator Lee.
Thanks. Just real quick, following up on this conversation, apologize, I missed the beginning of it, but what would stop me or anybody running for office from executing a contract, let's say now, for the 2022 election cycle, and in the contract, say I'm gonna mail, 4 or 5 things, or we'll decide on the dates once we get there, depending on what's going on in the race. And then I'd file now, acknowledging that, but ultimately there's no disclosure or real transparency for when that's gonna come.
Is that, who are you asking? I'm sorry.
Oh, I'm sorry for, I guess campaign spending.
Okay.
Yeah, I mean, you're right. I think I mentioned that in answering the vice chair's question. We run into that kind of a problem when trying to determine when the contract is executed, and I believe all contracts have an execution date, and if you have a contract, or at least whatever you want to call it today, to run 4 ads right like a week before the primary in 2022, I mean, at some point you have to commit to that, right? And I would think that would be your contract date.
Thanks. And the reason I brought this up, the more concerning thing for me, I mean, we all see the mail show up in people's mailboxes. It's pretty visible, and they're fairly large expenditures, so they're going to be caught somewhere at some point. But I think with the evolution in technology and the way campaigns are run now, the kind of traction you can get on social media for spreading something that's blatantly illegal or whatever it is, where you can spend $50 to do it, would not trigger the same kinds of transparency and oversight that something like a district-wide mailer would, but can have even more of a effect on the actual voters in the race. So I was curious, in this discussion, is that in there somewhere? I know bills in the past have tried to, especially for, I think we're less worried about, I'm less worried about candidates doing it because it reflects poorly on a candidate who spreads false information or what have you. But for third-party PACs and others that are non-candidate committees that are coming in, from the mainland or other places, they can spend almost nothing and have an outsized amount of influence in a race without the kind of transparency that I think the intent of this bill is designed to catch. So is that part of the discussion here, or is that a separate bill down the road that we might consider?
Yeah, I'm not sure if that's part of the discussion of this bill. Of course, the discussion is anything you guys want it to be, but I think this is premised on that people are going to be truthful and that they're going to know when their contracts are executed and then report then. What this bill is trying to do is just change that disclosure date from when the contract is executed to 24 hours after the contract is publicly available. I'm sorry, the advertisement is publicly available. So, I guess it doesn't address dishonesty or other concerns like that. It's
Thanks.
just a timing
Sure.
thing.
So, thank you. So Senator Lee, I know there is a what's called a micro-targeting bill that I introduced. I don't know if we're going to have time to deal with it this session, but yeah, at least from my perspective, there's certainly other things that we could look at, but it doesn't really come up in this bill, I don't think. Members, any other questions on this? Mr. Cam, I do have a question for you too. It's a little more on the technical side. Let me see. So the bill removes the phrase, quote, that constitute expenditure. So there's an exception to what is considered an electioneering communication, several exceptions. And one of them is items that constitute expenditures by the expending organization. Now you're suggesting to take that out, but I guess I'm not quite sure what the implications are. What was being excluded? What is being excluded currently by that phrase?
As far as in my experience, nothing has been excluded by that phrase, but committees were using that exception to say that committees are excluded from filing statement of information. When that is
because they're making expenditures on the advertisement.
Correct.
Okay.
Okay.
All right. I think I understand. I think that's all for me. Anybody else? Any other questions on this? Okay. Thank you very much, both Mr. Kim and Ms. Ma. We'll go ahead and move on to SB 405. This provides that excess contributions by non-resident contributors shall escheat to the Hawaii Election Commission Fund if not returned to the contributor within 30 days. On 405, first up is Mr. Cam, Campaign Spending Commission.
Good morning again. The commission stands on its written testimony support.
Okay, thank you. Ms. Sandy Ma, Common Cause Hawaii.
Good morning, Chair, Vice Chair, members of the committee. We support this bill. Thank you.
Thank you. Next is Bepi Shapiro, League of Women Voters in support. Tlaylock Tokuda in support. Carolyn Kunitake in support. Michael Galoyo Jr. in support. Edward Hanel Jr. in support. David Anderson in support. And that's it on 405. Members, any questions on 405? If not, I have a question for Mr. Cam. So I'm still not sure why, because the way this non-resident thing works now, it wasn't originally this way, but at the end of the election cycle, you're supposed to be under 30% of your contributions can be from out of 30% or under can be from out of
30% out, yeah.
So you don't know whether what or if any of the out-of-state contributions are illegal until after the whole thing is over, and they may have made the contribution 3 years ago, and so there's no way to return it within 30 days because you don't even know whether it's illegal, because resident contributions could come in the meantime and make up more than 70%. So
right.
Okay, as long as you're okay with, I'll have some amendments, but I don't think it's not your normal. It's not like when somebody they've already given you $4,000 and they give you another $1,000 if you're in the Senate, then you know immediately that that's illegal and you got to return it. So I get that, but this isn't that same situation.
That's correct. It is a different situation. But the law used to be, you look at every single disclosure period and you try to determine what percentage of the non-resident. Now the statute just waits to the very end. But I guess what I'll say to that is, if the committees regularly validate their reporting for each disclosure period, they'll get a running total. I don't know what other term to use, but of that particular of where you stand up to that point. I mean, obviously, if you're at 30% or higher, then you might have to start on thinking, well, I better stop accepting.
No, what you're thinking as a candidate, I better raise more money locally so that I can keep all that money from out of state. That's what you're thinking.
Or that, right? Take less non-resident, get more resident.
Yes.
But
exactly.
I think if the candidates do validate, or non-candidate committees validate their reports, you'll get a sense of where you're at as far as the percentage. So I don't think you're going to get, when the election period is done, you're going to say, okay, this one that came in 3 years ago for the committee, the committee members here who have 4-year terms.
Well, I guess my real question then is, it's not a violation until the end of the cycle, correct?
Correct.
Okay. Members, any other questions? All right, thank you. Let's go ahead and move on to the next bill, which is SB 406. Clarifies the Campaign Spending Commission personnel includes staff, and adds that the staff may initiate complaints on behalf of the commission. First up on 406 is Mr. Cam, Campaign Spending Commission.
Good morning again, Chair, Vice Chair, members of the committee. So we submitted testimony in which we are asking that the Section 1 be amended. It's to, instead of amending 11-311, that the amendment is made to, as stated in our testimony, to 11-314. I believe this addresses the common causes concern, which upon further reflection, we share with the common cause. Thank you.
Thank you. Next up is Sandy Ma, Common Cause.
Good morning again. We submitted comments, which the Campaign Spending Commission echoed. Thank you. Don't need to repeat them. Thank you.
Okay, thank you. Members, any questions? I'm sorry, that's all the testimony we have. Any questions, members? Let me just double check. I don't think I do. No. Let's go ahead and move on to the next bill, which is SB 413. Excludes violation of privacy in the first degree and certain subsections of violation of privacy in the second degree from qualifying for deferred acceptance of guilty plea or nolo contender pleas. First up on 413 is Lee Hayakawa, Office of the Public Defender. Good morning.
Hi, good morning. Chair Rhodes, Vice Chair Keoho Kalole, members of the committee. I am the Assistant Public Defender, and the Office of the Public Defender respectfully opposes SB number 413. If I might just briefly, I guess, sum up our testimony. SB 413 seeks to take discretion away from the judges, whether it be a circuit court judge or a district court judge. Our point being, judges undergo a rigorous vetting process. They are subject to Senate confirmation. They have to get through the JSC first, obviously. They get picked either by CJ Rechtenwald or Governor Ige. A lot goes into picking our judges, and our point is we should trust our judges. To take discretion away from the judges is problematic. And having been a frontline attorney for many years, I have seen situations where the judges' hands were tied. And in a case like these, the violation of privacy in the first degree and the second degree, all cases are different, all individuals are different, and our position is that we should still leave the decisions up to the sound discretion of the sitting judge. Thank you.
Thank you very much. Next, we have Tricia Nakamatsu for the Department of the Prosecuting Attorney in Honolulu in support. And that's all the testimony we have. Members, any questions for Mr. Hayakawa? Senator Keo Kalole.
Is the prosecutor's office on?
No, they. I believe what happened was that they submitted too late to sign up for the.
I see. Thank you.
The link. Yeah.
Yeah, that's okay. Thank you.
Any other comments, concerns?
I had questions for the
Senator-
prosecutor
Oh,
as well, so I
okay.
guess that we'll talk about that later.
Okay.
Thank you.
Anyone else? Okay, seeing none, that's the end of the agenda. Unless someone feels like we need to go into a breakout room, I'm prepared to go ahead and make recommendations now. Anyone want to go into the breakout room? Okay, seeing none, let's go ahead and go to decision making. Going back to the top of the agenda, which is SB 385 relating to Uniform Trust Code. Recommendation is to pass with amendments, just technical amendments. Any questions or concerns? Seeing none, Vice Chair.
Members, we are voting on SB 385. The recommendation is to pass this measure with amendments. Chair Rhodes.
Aye.
Vice Chair goes aye. Senator Ocasio.
Aye.
Senator Gabbard.
Aye.
Senator Kim.
Aye.
Thank you. Senator Lee.
Aye.
Senator Favela.
Aye.
Thank you, Chair. Your recommendation is adopted.
Thank you. Moving on to SB 402. This provides that expenditures by candidate committees may be made to reimburse individuals other than the candidate him or herself, and deletes candidate reimbursements from the category of expenditures that non-candidate committees must itemize in their reports, since non-candidate committees are not allowed to receive or make loans. Recommendation here is to pass as is. Questions or concerns? If not, Vice Chair.
Members voting on SB 402, the recommendation is to pass unamended. Noting the presence of all members of the committee, are there any members with reservations? Any opposition? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thank you, members. Next is SB 404. This increases the monetary threshold that requires disclosure of electioneering communications. Requires that disclosures of electioneering communications occur on the date the electioneering communications are publicly distributed. Classifies election advertisements sent by mail at any postal rate and election advertisements that are expenditures of an organization as electioneering communications. The recommendation here, this is an issue that I'm still not totally happy with how this result, but I think it's better than what we have right now. And So my recommendation is to pass it as is. Questions or concerns? If not, Senator Keokalole.
Members, this is SB 404. The recommendation is to pass unamended, noting the presence of all members of the committee. Any opposition? Any reservations? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 405, provides that excess contributions by non-resident contributors shall escheat to the Hawaii Election Campaign Fund if not returned to the contributor within 30 days. Our recommendation here is to pass, but with some amendments as we discussed during the testimony. This is not your normal situation. You don't know whether you've committed a violation until the very end. So I'm going to recommend that any excess out-of-state contributions escheat to the state 30 days after the election period's last report is due. The election period's last report, and that candidate committees may choose which out-of-state contributions to return to bring the committee into compliance. So if you get to the end, you discover that you've got 35% from out-of-state, then the candidate committee can decide who to give the money back to bring themselves into compliance. And if they don't do so within 30 days, then it does escheat to the CSC. Questions or concerns? If not, Vice Chair.
Members, we are voting on SB 405. The Chair's recommendation is to pass with amendments, noting the presence of all members of the committee. Is there any opposition? Any reservations? Seeing none, Chair, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 406. This clarifies that the Campaign Spending Commission personnel includes staff and adds that the staff may initiate complaints on behalf of the commission. Recommendation is to pass, but with some amendments. I think this will address the concerns of Common Cause and the commissioner. So we'll clarify that the staff of the commission may initiate complaints, but that the staff members are not members of the commission. So, any questions or concerns? If not, Vice Chair.
Members, we're voting on SB 406. The recommendation is to pass with amendments. With all members present, is there any opposition? Any reservations? Chair, all members vote aye. Recommendation adopted.
Thank you. Next up is SB 413. This excludes violation of privacy in the first degree and certain subsections of violations of privacy in the second degree from qualifying for deferred acceptance of guilty plea or nolo contender. I'd like to move it forward, but I did note because we didn't have the prosecutor here and because I think there's some hesitancy on some parts, some members on the committee here, I'm going to just put a bad date on it. So May 6, 2137, and that would be the only amendment, and we'll take it up at conference if it gets that far. Questions or concerns? If not, Vice Chair.
Members voting on SB 413, the recommendation is to pass with amendments, noting the presence of all members. Is there any opposition?
I vote no.
Reservations?
Hang on. Sorry, go ahead.
I have a no vote from Senator Ocasio. Any other no votes? Okay, I have reservations from Senator Favela. Any other reservations? Chair, all other members vote aye. Recommendation adopted.
All right, thank you very much. I believe that concludes our business for today, and we have tomorrow off for committee hearings. We do have one on Friday, though. Thank you very much. I'll talk to you soon.